So you've just started the lawsuit. What's the process? Well, time-wise, it takes about 1 year from the date of filing to mediation, which is usually when you get a check. So the first part is the lawyer files a complaint, and that just says the other party was negligent, the other party was at fault. My client suffered, had medical bills, lost wages, and whatever the other claims are. They have 20 days to answer, and they'll file an answer that says, hey, we're not at fault, or if we are, we're only partially at fault because you're at fault for it too, and you have pre-existing medical conditions. This accident didn't cause these injuries, whatever their defenses are. Then from there, we start the discovery process, and this is the work. So the first part of discovery, the defense is going to send us certain things like questions. Fancy lawyer word is interrogatories, but they're just questions that you have to answer. Everything from your name, your date of birth, your any kind of prior accidents that you may have had, where you work, where you've lived for the past 10 years. So there's a bunch of questions. Then there's also requests for admissions, and this just means, do you admit certain things or do you deny them? So they ask you questions there as well. For instance, do you admit that you weren't wearing a seatbelt? I deny that. I was wearing a seatbelt. That's just one of the questions. Then you also have what's called request for production. And largely this is my job to get them everything. And what is that? Medical bills, medical records, photos, videos, these sorts of things. Now, we'll be asking you for help on certain things. For instance, if there's a wage loss claim, they're going to need the last 7 years of your tax returns, your W-2s, this sort of thing to help with that claim. Then, once we get that, then I send them our discovery as well. And you won't have to worry about that. That's work that I do kind of behind the scenes. But it'd be, our request for admissions, request for productions, and interrogatories, fancy lawyer word for questions. After that, and this will be a few months going through that probably, you'll sit for what's called a CME, and that just means compulsory medical examination. This is an examination where you get examined by the defense's doctors, and they all say the same thing at the end. I could write the reports for them. It says, you're not hurt, or if you are hurt, it's not our fault because it's a pre-existing condition or it's degenerative, you're old. So generally that's what they're going to say. These CME doctors, they're not your friends. They're getting paid by the defense to say what the defense wants them to say. So after that, you will sit for what's called the deposition. And that's just a chance for the lawyers to ask you questions. There'll be a court reporter that types everything down. And most of the time these days, that's all done by video. So you're not going to have to go to a court reporter's office, most likely. Most of the time it's all done by video. And I'll prepare you for that. And, certain rules. I actually have a video, top 10 tips, say that fast 10 times, on how to give a deposition. So you review that, you take the deposition. We'll take the deposition of the person who's at fault. And down the road, we'll have what's called a mediation. This is usually where cases settle. So it's going to be at least several months to a year, typically, for that mediation date. And what happens at mediation? Well, each side presents their side of the story. So typically the plaintiff, I, as your lawyer, will go first. You won't have to say anything. I will lay out the case, lay out why the other person is at fault, lay out your medical bills, your pain, your suffering, lost wages, whatever the claims are. I'll lay those all out. Now, I typically will say whatever the best facts are, but I'll let them know, look, this is where the case is weak. And what that does is that takes a little bit of the steam out of the other side's argument. So what I do is I take that and I say, this is my weak point, but here's why it's not so weak. Then the defense will present their side. And then after they do, the mediator will put us in separate rooms. They're separate virtual rooms. So we'll go into a room, and then the mediator will come in, say how much you want. And we'll say, we want $1 million. And then he'll go in the other room. How much would you like to pay them? Well, we'll give them $10 to go away. And then they'll go back and forth, and this goes on for hours until hopefully we reach some kind of a decision where we have an agreement. So once we reach an agreement, the mediator will send electronically something for you to sign, for me to sign, and the other side to sign. Says we got an agreement. They're going to pay us X amount. We're going to drop the case. Then from there, usually takes a week or 2 weeks for me to get the check. Once I get the check, I deposit it. It takes a few days to cash. But during that time, what I'll do is reduce the medical bills as much as I can for you. Now, it makes no difference in my fee, but I want you to be happy because every dollar that's reduced on the medical bills, this is an extra dollar in your pocket. So that typically takes 4 to 6 weeks to get all those medical bills down. Could be more depending on the case, but just to give you kind of a general timeline, that's kind of where it is. Now, if the case settles there, that's the end of the case. If you got to go to trial, figure it could be another year because you're waiting. You're going to go to the trial docket and the judge's going to say, you ready? Yes, we're ready. Oh, by the way, we've got 25 cases in front of you. So the judge is going to take the oldest case first. That's going to be from 3 years ago or something stupid. And then you're just going to get kicked. The can's going to get kicked down the road a bunch of times. So if the case doesn't settle in mediation, we have to ask ourselves, why? Because 99% of cases, they settle in mediation. Usually there's a problem with the case. So we have to, be honest with ourselves, like, okay, what's the problem here? Because to the insurance companies, this is simply a business decision. They're like, okay, I can pay Great Tash and his client X amount to go away, or I can pay these lawyers, to fight the case. If I really think we can win, I'm going to do that. So if they think there's a problem, for instance, with liability, like their client's not at fault at all, they're going to fight that. Typically on a low property damage case, let's say there's a fender bender, but it's not much, it's $500 worth of damage or something. The lawyer's going to get up, the insurance lawyer is going to get up there and say, this accident, this little bit of property damage did not cause the injuries that the plaintiff is claiming. And then they're going to sit down and they're probably going to win that case because, it's hard to believe that certain, if you're seriously injured from like a scratch on a car, like nobody's believing that. So that's just one example of when they push, and they'll go to trial and they'll pay their lawyers because they're like, no, we can win this case. But most cases, they're going to settle a mediation. So you figure from the date the lawsuit is filed, hopefully a year, maybe less, maybe more. If it's got to go to trial, you figure it's going to be 2 years approximately, give or take. So that's just an overview of the lawsuit process, the different things kind of that go on. There's other little nuances, but I just wanted to give you an overview, and hopefully this helps. Until next time, this is Gray from GrayTash.com. Remember, law is not black or white, it's gray.